That's a good sign. Okay, so I'm gonna go ahead and get started. We do have a lot of introductions sort of at the beginning. Welcome everyone to our third and final small business webinar in the Modest Means Helpline small business webinar series. Our presentation today is estate planning for New Mexico small businesses. My name is Brecken Larson. I'm a staff attorney with the Modest Means Helpline, and our presentation today is co-presented by Christina Cavalieri from Law for Small Business. And Christina, if you want to do a little introduction now, that would be great.
All right. Hi, I'm very excited to be here with the Modest Means Helpline. My name is Christina Cavalieri. I'm an attorney at Law for Small Business. I love estate planning and estate administration, so it's a good fit for me to be helping with this presentation because there are special concerns for small business owners. So I'm very excited to be here.
Yeah, we're very happy to have you. And also I will serve as the moderator during this presentation. So if you have questions, if you can type those into the Q&A, I'll try to monitor that and pause to try to address those as we go through the presentation. But okay. Let's go ahead and see. Okay, so the Modest Means Helpline, if you don't know, is a civil legal telephone helpline that is operated under the New Mexico State Bar Foundation, and it assists New Mexico residents with incomes below 500% of federal poverty. And the MMH assists on several types of civil legal matters, including small business issues, advising on small business issues. And you can reach our helpline between 8 and noon, Monday through Friday, at 505-797-6013. That is our main intake number. Also, a disclaimer, this presentation provides attendees and viewers with general legal information. The presenters are not providing legal advice and are not entering into any attorney-client relationship with any attendees or viewers of this webinar. We will not be discussing specific situations, so please refrain from asking fact-specific questions. You can call our helpline or Christina with your specific questions after the webinar. And the presenters of this webinar are not providing an opinion or advice as to whether any particular estate plan or estate planning strategy is the most beneficial or otherwise for your specific situation. The information provided is for purposes of providing examples only, and attendees or viewers are not authorized or permitted to use any of the contact information shown in this webinar, including but not limited to names of individuals or entities used as examples for agents, personal representatives, trustees, or otherwise. Also, the State Bar's website is sbnm.org, and you can find a link to the 2 previous webinars in this series under the For Public tab at the top, For Public. And then if you click on Modest Means Helpline on the left-hand side, and then on MMH Publications, you can see our 2 previous videos are linked here, and we will link this presentation on this same webpage as well. Or you can go to the State Bar of New Mexico's YouTube channel, and you can find our first 2 videos under the Videos tab. Here's the second one we did, and then here's the first one. There's some other videos on that tab as well, but those are the videos in this series. Okay, so in this presentation, we'll be covering estate planning topics and strategies as they relate to small businesses and small business owners. So we wanted to start off by explaining some estate planning terms that we will be using and that might be new or unfamiliar to you. Christina, do you want to start off or explain a couple terms and we can kind of go back and forth?
Sure.
Okay.
So we'll go into depth about these terms, but this is a little bit of an outline of what we're going to talk about for the estate planning part, and then we'll do the small business part and then bring it all together. So some estate planning terms that you may have heard, you may not. There's the estate. That is everything that a person who is now deceased owns, a deceased person's stuff. An estate plan, the documents that are instructions as to what to do with that stuff. Financial power of attorney is a document that allows another person to act on behalf of a person. A will is part of an estate plan. It's some of those instructions. A trust is another form of instructions that can be useful while someone is alive as well as once they're deceased. And probate is a state law process that transfers ownership from the deceased person's estate to its next owners as set forth in the estate plan. And we'll go into more detail about all of those in future slides.
Yes. Go ahead and go to the next one. So we'll start off with the financial power of attorney. Do you want to take that one as well, Christina?
Sure.
Okay.
So powers of attorney are their documents, their contracts, and their structure is, again, a set of instructions or powers, and their function is that they allow a principal, that's the person executing the power of attorney, to designate an agent, which is it's technically called an attorney in fact, but some people just say, I have my mom's power of attorney, or I am my mom's power of attorney. So the power of attorney is a document that it designates who can act on behalf of the principal and what they're allowed to do. Some powers of attorney are for medical decision-making. Some powers of attorney are for financial decision-making. They're very customizable. Generally, the default powers of attorney are designed for in a case if the principal becomes incapacitated and can't transact business on their own. They expire automatically when the principal dies, so they can't be used as the estate plan, but usually this is a document that we think about in connection with someone's estate plan. So the financial power of attorney for business owners can be used so that if the owner of a business is the person that needs to pay the business's bills, it's nice to have a backup in case the owner of the business is unable to pay those bills.
Yeah. And so in relation to thinking about naming or designating an agent for a financial power of attorney, but also in keeping in mind kind of these concepts for the types of people that you would want to name in another capacity to serve on your behalf as a business owner or as an individual that it also has an estate plan that could include some of your business assets. Some considerations while you're thinking about who you might want to name as an agent is naming one person as opposed to naming multiple co-agents. It can get a little tricky in designating or being really clear about if you have multiple people, do they have to both agree? Do they have to have unanimity before they can make a decision? That can just add some complications. Also thinking through someone who it's within their capabilities to be taking these actions on your behalf, and also thinking about the proximity of this person to you or to where your business is or to where you live. So thinking about people who are in New Mexico as well, or the closest to New Mexico of all of the possible candidates. And then also as a best practice, in considering those three things, and then also we recommend that you designate somebody that you trust and who would be able to operate your business while you're incapacitated. That's sort of just a general best practice from the financial power of attorney standpoint. Any other comments on that?
Not for me. Thank you.
Okay. And nice. Nope. Okay, this is the next one. Okay. So do you want me to take this one? So Will?
Yeah, that'd be great.
Okay. So the next document that you might have in your estate plan, as part of your estate plan, would be your last will and testament, which is the shortened version of that is just referred to as your will. The structure and function of this document is it can do a lot of things. It can designate who your family members are and define who your family members are. You can say what you want to do with your last remains. And then specifically in relation to thinking about business assets, there can be a section in your will that provides for a specific devise or specific devises. A devise is a gift, and the recipient of that gift is a devisee. And so within your will, you can make a specific devise of your business ownership interest to the person, the recipient that you would like to be the devisee of that business ownership interest. So there's that section that can be in your will, or there can be multiple sections depending on the types of assets that you have. This would be one area where you could dispose of, or sort of, again, sort of give instructions of how you would like this asset to be transferred upon your death. The other very important piece of your will is that it allows you to designate your personal representative, which in New Mexico, and other states, sometimes those are referred to as an executor. But in New Mexico, it is a personal representative. And this person would be the person who would be tasked with filing a probate to probate your will. And so again, in thinking through the types of people that you would want to name as your personal representative, or the type of person, keeping those considerations in mind of designating one person to serve as your PR as opposed to multiple co-PRs. And also thinking through that specific individual's capabilities, their proximity to you and to New Mexico. And ultimately keeping in mind that when they, and we'll talk about probate a little bit more, but when they're tasked with, trying to effectuate what you've put together in your will, that this personal representative owes a fiduciary duty to the heirs or the beneficiaries of your estate, the people who are to receive the assets from your estate. And they do not owe any type of duty to your employees or your business partners. And so thinking through this person's relationship to those people might also be a consideration. Someone who you would like to serve in this role from a estate planning side, or from the sort of estate side, which can be a bit more personal. But sometimes there's overlap depending on your facts and circumstances and the people that you're working with. And overall best practice is that your will matches the governing documents of your business. And we will talk about the types of governing documents that relate to different types of entities in New Mexico. But that however you might be disposing of your, or instructing someone to transfer your business assets, that matches what the documents related to your business, how that process goes when a member or a business partner passes away. And so you're wanting to make sure that those don't conflict with each other, and that they more so work together or match each other. Any other comments about wills, Christina?
No, that was very good.
Okay. I'm not seeing any questions so far. Remember, if you have any, feel free to put those in the Q&A, and we'll go on to the next. Do you want to take trusts?
Sure. So trusts, you may have heard of trusts. I'll just give a brief background on them. I think trusts are kind of cool. So I don't know if this was how trusts were invented, or if this is how they first became popular in historical law, but during the Crusades, the Crusaders in order to be a Crusader, I think the rules early on were that the Crusaders had to own land. And so they were going off to war, leaving big estates. And usually, the society was pretty segregated in terms of gender. And so they were leaving wives and children who weren't allowed to run or own property. And so they would name a trusted friend or relative to manage their property while they were off at war. And that's where we get the name trust. And so in this example, the function of the structure of the trust is that the knight going off to the Crusades is the settler. That is the person who makes the trust. The trust is the document that has the instructions for what's supposed to be done while the settler was away. The settler's estate is the corpus, which is body. So that is the body of the trust. That's the property that is in trust. The beneficiaries would be the wife and the kids and anyone else who has the property run for their benefit. And the trustee is that trusted friend. And so we still have trusts today, and the purpose of trusts is still the same. It's a way for an owner of some property to have a document that gives instructions to someone they trust, their trustee, to manage that property for the benefit of someone else. So if you use a trust as part of your estate plan, we sort of contract all that so that we can expand it again. You would be the settler of the trust. The corpus would be whatever you decide to put into it. Usually in a living trust, which is the estate planning document that you might use, you would also be the beneficiary of the trust because it's your stuff. You want it to be run for your benefit. And you would be the trustee because you trust yourself to run your property. So why the heck would we do this with your stuff? Well, a trust doesn't die. And so if a trust is the owner of property, that property won't be owned by someone who has died. So your trust will take the place of your will. It will have instructions about the successor trustee who's supposed to take over after you die, and the successor beneficiaries who take over as the people who benefit after you die. So the most important thing about a trust is to make sure that you put things in it. If you make a trust, you have this beautiful document that won't die. But if it doesn't get anything in that body and that corpus, then you still own all your stuff when you die, and you have this nice empty trust. And so we help clients and ourselves in a few ways by transferring the property into the trust, or we will do something called a pour over will, and that catches anything that you didn't manage to put into the trust. And it pours it into the trust after you've died. The problem with the pour over will is that a will still need to be probated. So your estate will still have to go through probate to probate that pour over will. So the best practices with trusts, make sure that while you're alive, you put things in your trust. That's pretty much it.
Best practice, yes, is funding the trust. Okay, we had one question that is, which you sort of answered, but we can clarify here. What is the process to create or file a trust?
I can take that.
Okay.
So creating a trust, this is where I'm going to recommend that you hire an attorney. I'm not saying that people can't create trusts on their own. There are forms on the internet. It's a little bit tricky. They're a little bit more of the advanced, like the blue square, the black diamond forms in terms of doing it yourself. But trusts don't have to be registered in New Mexico. So once you have the trust, it's just a matter of talking with your attorney, or, if you're willing to take that on yourself, thinking about who's going to play all these different roles, and then what the instructions are going to be, and then making sure that you just execute the document, sign. It doesn't have to be notarized, but sometimes that gives it an air of formality, and make sure that your trustees know where copies of documents are, and that they have been named successor trustees or, initial trustees. And yeah, it's kind of like a contract. It's just a matter of getting it written down and signed and then funded.
Okay.
And the next question was, what is probate, which I think might be our next slide. So.
Good timing.
Yeah.
Do you want me to talk about probate?
Sure.
Talk about probate. Okay.
Yeah.
Okay. So probate is, as Christina mentioned before, It is a state law process that is run through the courts, essentially. The purpose of a probate is to probate someone's will. So when someone does not have a trust, or they have a trust, but they only have a pour of a will and they didn't fund their trust, so then the pour of a will has to be probated. The purpose of a probate is to appoint the personal representative if that's been designated in someone's will. If it hasn't, you can still file and probate an estate, open a probate for an estate that isn't governed by a will. And the purpose being for that personal representative to identify all of a deceased person's assets and to identify all of their debts and to pay off their debts and to distribute the property that they left at the time of their death. And you can file, as I mentioned, if someone dies with a will or without a will, you can file a probate. If you die with a will, it is called filing testate. You have died testate, meaning you have a will. If you don't have a will, it's called intestate. And there are very specific circumstances that would mean that you need to file in district court in the area of New Mexico that you live in. But absent those specific circumstances, you can instead file through probate court, which is the court that would be in the county that you live in, or the court that's in the county where the deceased person was living at the time of their death. And if you file in probate court, the probate is considered to be an informal probate. If you are filing, or if the circumstances mean that you have to elevate the case up to district court, or you have to start out in district court, it's considered a formal probate. So there's lots of different options or sort of funky things there. In general, if you're filing a straightforward informal probate in probate court and you have a will, at its most efficient, a probate will take about 6 months to complete. And again, the purpose being to appoint a personal representative, the person that's in the will, or if there's not a will, there's under the state statutes a level of priority of who can serve. But as Christina sort of mentioned in the previous slide, if you instead have an estate plan that involves a properly funded trust, then you are avoiding this process entirely. And probate is somewhat public. You can, people can see or potentially find or review records of probates. So in general, a best practice would be that you are fully advised as to how your estate plan is structured, whether that's going to make probate inevitable. And if so, if probate is inevitable and a probate happens, it is very likely that it will cause an interruption in your business. Or if your estate plan is structured that your estate plan and governing documents allow your PR to avoid probate and avoid some type of potential interruption in your business. Because again, when you're thinking through, if you have business partners and employees who aren't named in, as your personal representative, which could be sort of common or proper, it totally depends on your circumstances. It's going to be some other third party from your business who is handling your estate and handling your interests in that business that you could be running with other people. And so that is how this could potentially cause an interruption in your business. Any other comments, Christina?
Maybe just one. Brecken and I have both worked in probate cases in estate administration, and both of us like probate. Probate is an efficient process. It's like a lawsuit because you file with the court and you get a court case number. And the court just sort of helps your personal representative get your stuff to its next owner. So whether your estate plan will be one aimed at avoiding a probate or one aimed at an efficient probate, that'll be completely dependent on the needs of your estate. So if you end up with an estate plan where your real property is headed to probate, that's okay. That might be the best thing for you. So we're not here to sell you probate avoidance.
Okay, a couple questions. We'll just take them in order if you want.
Okay.
How do you fund the trust? So do you want to give some examples of how to do that?
Sure. It depends on the stuff you're putting in the trust. It can be very easy. You can just make a document that says, you know, I, Christina, am the owner of a membership interest in an LLC, and I assign that membership interest to the trust. So that's one pretty easy way. For a bank account, you would go down to your bank and give them your trust document or your certificate of trust, which I think Brecken will talk about later, a certificate of trust. But and you just say, hey, can you change my bank account to the Christina Cavalieri Living Trust? And so then that bank account is in the trust. For real property, which is the one that really kind of sticks people up, because real property has to go through probate if a deceased person owns it. Real property has to be deeded to the trust. So you will need to get a deed, sign it, and record it with the county clerk and recorder. And I do recommend going to an attorney or a real estate professional for that, because you can kind of cloud the title to your real estate, which ends up being kind of expensive to fix later. So it depends on the kind of property, but those are the main examples. For your own personal stuff, just a note in the trust language itself that says, you know, I, the settler of this trust, have put all my personal stuff in it.
And you can also get really particular and add like a schedule to your trust agreement and literally list out all of the things, which is a very organized thing to do, just to keep track of everything that's in there and to very clearly show I funded this trust. So the next question, it's kind of related, that if a trustee dies and the successor trustee comes to be the new trustee, how does the new trustee show that they have authority and that they are in fact the trustee? Do the trust papers need to be stored in a certain way, and are they ever contested? So I will talk about this, a certificate of trust, which is basically a one-page, well, I'll talk about it now. It's basically a one-page summary that doesn't share the all the details and sort of personal information that's in your trust agreement. It literally states the name of the trust, when it started, who are the trustees and the successor trustees, and it identifies those people. And it has some other language in it, but it's kind of 1 to 2 pages max. And that document, that certificate of trust, that's what you could provide to show authority. As a new trustee, you're probably going to need to show like a certificate of death for the previous trustee, that type of thing. But the certificate of trust is a handy document so that you don't have to give away your whole trust, so that, you know, to a bank or to whomever is asking for a copy of that. Trust papers in terms of storage, I recommend a fireproof safe, multiple copies, keeping the originals in a really, really safe way. Christina, do you have any other?
And on the cloud somehow, like, and you can even get as unsophisticated as emailing yourself a copy.
Yeah.
Just to make sure that you have a copy stored electronically as well.
Yeah.
Are they ever contested? Boy, are they ever. So that'll be a lawsuit, and the potential for a trust contest, that is usually beneficiaries will contest that they're not getting enough distributions from the trust. That's the most common litigation. You could also have natural heirs, so people who feel that they should have inherited property through a will or through the intestate statute, who were cut out of the trust. So disinherited folks, they might sue to contest the trust. So the beneficiaries, they would sue for breach of fiduciary duty if they thought the trustee was not treating them fairly or like equally to the other beneficiaries, or the trustee was keeping too much in the trust corpus and favoring the trust corpus rather than distributing to the beneficiaries. So that would be breach of fiduciary duty. And then for the disinherited folks, those pretty much come down to undue influence. So if they feel that undue influence was exerted on the settler, which is hard, that's kind of a hard argument to make because a trust is not super easy to get. You know, you have to go back and forth with your attorney and have a pretty specific plan in mind. But those are the big litigation avenues.
Yeah. And then the last question that we have here is, may you please clarify the difference between a trust and a will? That's a good question. So in thinking through the types of documents that make up an estate plan, one version of that, of an estate plan, would be that you have your financial power of attorney that we talked about, that you have an advanced healthcare directive, which is the medical power of attorney essentially, and that you have a will. That could be a very simple way of creating an estate plan for you that covers your bases for two documents that are used while you're living, and then your will to instruct people what to do with your stuff once you pass and who can do what. So the will, if you only have a will, you don't have a trust, the will likely need to be probated so that everything can be distributed as you've identified. If you want to try to avoid probate for various reasons, and there are a lot of reasons why you should or shouldn't, and as Christina mentioned, probate is very straightforward in New Mexico. We're not trying to, trying to avoid probate on anyone or everyone. But if instead you decided that you wanted to avoid probate and have a trust that holds all of your assets while you're living, and then also that continues holding it after you've passed, and that would help not cause, help facilitate, continuity of your business operations, then the trust would help do that because you're not having to file a probate in between. So if you, in that second scenario, you would have your financial power of attorney, your advanced healthcare directive. You're likely still going to have, just in case as a catch-all and a safety net, a pour over will, which is going to scoop up stuff just in case you didn't put it in your trust, and then you're going to have your trust. So you're going to have, there's a couple of different scenarios, but yeah, I hope that kind of helps in clarifying that. If not, ask a follow-up question, please. Okay. So now we're going to switch gears and talk about, so we just kind of talked about estate planning documents. Now we're going to shift gears and talk about businesses and the governing documents that are related to different kinds of business entities, and then kind of roll in how estate planning also relates to those. So just some basic terms before we talk about each of these entities. The limited liability company, or the LLC, is a type of business entity. The governing document is its operating agreement. That's a document that sets out business operations for an LLC and a lot of other things we'll talk about in more detail. The type of ownership interest in an LLC that a member holds or an owner holds is called a membership interest. It can also be called a unit. For a corporation, which is a different kind of entity, the governing document is a corporation's bylaws, and the ownership interests are referred to as shares. For a partnership, the governing document is a partnership agreement, and the ownership interest is a partnership interest. And for sole proprietorships, we'll talk about that a little bit more, because sometimes those don't have, those just have more general terms to refer to their governing documents, if any, and their ownership interests in general. So we'll start with the LLC. Christina, do you want to take LLC?
Sure. So LLCs are very popular. So they're very common. Many of you might have one or more LLCs. They are formed by filing articles of organization with the New Mexico Secretary of State. Their structure is, their owners are called members. and the members have a membership interest or units of the LLC. That will all be found in your operating agreement, as well as you'll designate whether your LLC is manager managed or member managed with the Secretary of State. That's one of the questions they ask you. But your operating agreement is really the skeleton of your LLC. And if you don't have a good skeleton of your LLC, then it kind of like falls apart when things happen to it. So it's really important to have a good, long, complete operating agreement. If you don't have an operating agreement, New Mexico state statutes kick in. And that would be okay if New Mexico state statute gave you a skeleton, but it's really not a whole skeleton. It's like, maybe a femur and maybe a humerus. And so your LLC is not very solid if you're just relying on the New Mexico state statutes. And so if the owner of an LLC dies, what happens next is going to depend pretty greatly on what it says in the operating agreement. And operating agreements can be structured, and on that owner's estate plan. And operating agreements can be structured for a world of different possibilities. It's good to make sure that the operating agreement, if the operating agreement says, my business partners shall have the right to buy out my membership interest, but the will says it is my wish that my daughter take my place in the business. Now you have a conflict, and your business partners are left with, should we be trying to buy out the estate, or should we be welcoming the daughter as our new business partner? And the daughter is thinking like, I don't even want to be part of this business. Why did my dad leave this to me? So it's good to make sure that the operating agreement and your estate plan match, because that'll tell your remaining business partners and your personal representative what your wishes were, and everyone's probably going to be trying to honor those wishes. And so that's sort of the interplay, and we'll talk more about it later, I think, but the interplay between death and owning an LLC.
Yes, and best practice that things somewhat try to not conflict to the extent that they can between the documents that you have in place. Okay, so, and we also had on this, and this is sort of also generally the state statutes that govern these different types of entities are in different parts of the state statute. But generally, again, if you don't have a governing document that sorts out what happens when someone passes away, the state statutes that govern buyout processes and that set those terms of how those even go. I mean, you can put something different in your operating agreement as to how that's all structured. And Christina and I, when we were preparing for this, had mentioned that that under the state statute, sometimes it's put into play that a business has to be appraised, and that can be, I put down $7,000 to $15,000 just to go through the process of having a business appraised in order to determine what someone's ownership interest is valued at, and how that, so it can, if things conflict, or if you don't have a governing document, there can be some really serious expenses that come into play really quickly. So the next entity that I'll talk about very briefly is the corporation. And so a corporation is another type of entity in New Mexico that has some formalities behind it, meaning that you have to you have to form this type of entity by filing articles of incorporation with the New Mexico Secretary of State, and paying a filing fee. And in general, the structure of a corporation is that there's a board of directors who make the business operations decisions, and then there are shareholders who own shares in the corporation. That is their ownership interest, and that is sort of their relationship. They the shareholders often have voting rights. There's a whole kind of relationship between those two roles of people. The governing documents of a corporation are its bylaws. And another thing we wanted to mention, briefly, is that it might be a little confusing if you have another type of business entity, but that you make an election that you be taxed as a C Corp or an S Corp, which are corporations, that you elect to that status as your tax filing or tax election of how your entity, so like your LLC, you could elect to be taxed as an S Corp if that's what's beneficial to the LLC. But distinguishing that from the actual underlying business entity being a corporation, which is different from an LLC. We wanted to note that. But in general, best practice, corporations are complicated than the other, more complicated than other types of business entities. And we recommend you contact your estate planning and business law attorneys to make sure that the type of interest you have in a corporation will be addressed in a way that's most beneficial to you. Okay. I can take partnership too if you want.
Okay.
Okay. So partnership is moving down sort of the scale from formal to less formal. A partnership can be formed in an informal way, which means you don't register with the Secretary of State, or you can formalize a partnership in New Mexico and register with the New Mexico Secretary of State. A partnership can be formed informally when two people agree to start and run a business for profit. As simple as that. At its most basic structure, the people who own the business, co-own, or who run the business, they are referred to as general partners. They have an equal interest in the assets and debts of the partnership. They have equal authority to take actions unless it's otherwise set out in the partnership agreement. But under the state statutes, it's kind of a 50-50 type of split. And the general partner's ownership interests in the partnership itself are referred to as partnership interests. Ideally, a partnership at least has a little bit more formality in terms of having a partnership agreement that governs the relationship between the partners, any other sort of split or authority that either general partner might have. And if you don't have a partnership agreement, the buyout process, if someone passes away, if one of the general partners passes away, is going to be outlined in the New Mexico state statutes, which could just set and mean some things that aren't quite as efficient as you're wanting, or could, cause the business to incur some substantial costs just to sort out, getting through that particular event happening. Best practice, again, that your partnership agreement matches your estate plan in terms of what happens when a general partner dies. So making sure that nothing conflicts there to try to keep the continuity of business operations in mind. Anything else on partnerships?
One thing I thought of after we prepared this, something I run into a lot is accidental partnerships, where so if two or more people are doing business together informally, that's a partnership. So a lot of folks who think that they're not in partnerships, they think they're just like, I invited my sister-in-law over to help make tamales for my tamale business, without some kind of formality, even like just a memorandum of understanding between people. You'll end up being partners. You can end up in a business partnership. So something to watch out for, but that was all.
Okay. I'll let you take sole proprietorship if you're good with that.
Yeah. Okay. So a sole proprietorship, some of you might be in that now. That's informal. There's no registration required with the Secretary of State. You might be a sole proprietor, as in you're the only one in your business, but you also have an LLC because you were smart and wanted to limit your own liability from your business activities. But a sole proprietorship with no LLC or corporate structure is it's very informal. It's you, and then if you have employees, they work for you. The ownership interests, it's your sole proprietorship. Your business assets are just your personal property. There are no governing documents for a sole proprietorship absent another corporate structure. So your personal representative from your estate or your trustee, if you go with a trust, chooses how to distribute your business assets and to whom, or to hire professionals to do that. And again, your personal representative owes duties to your heirs and devisees of your estate, not to your employees, not to your customers. And so the best practice with a sole proprietorship, make sure that your estate plan outlines how you would like your business to continue to operate, if you want your business to continue to operate, or and then how your assets are to be tied up and distributed.
Okay, I'm going to keep, there's a couple questions that we have that as we kind of keep talking, we'll see if we sort of answer those. And if not, we will at the end, or try to at the end, as we keep moving. I'm going to let you take the next couple as well.
Okay.
Yeah.
So now business estate planning strategies. So one estate planning strategy that I kind of like, my old boss used to say, being of sound mind, I spent it all. And so one estate planning for businesses strategy is to make these decisions while you're alive. And so that could mean gifting or selling your business assets to your business partners. Maybe if you have a kid in your business, it might be time to start, transferring ownership interest to the kid, as part of a retirement plan or a succession plan. Looking at businesses that have maybe run their course and that are still hanging out there and winding them down to dissolution, so that you're not leaving a kind of zombie business for your personal representative to close. You can also leave it for your personal representative to close. You don't care what that person thinks, you're dead. So leave them to close or wind up your business, but allowing them or giving them those instructions. And then drafting your governing documents so that the business ends when the partner or member dies is an option. And then I think we have more options on future slides, so I'll wait to talk about those.
Yeah. Next slide is family businesses, which kind of
We've talked kind of a lot about those today. We're in a family business mood. Family businesses come in all of the structures we've discussed. So family business is sort of an additional layer. There are a lot of contract and estate planning techniques that can protect a family business. There are like mutual wills that will really put the family business as the most important thing. These sometimes come with consequences to consider. So the non-involved family members, if you're trying to preserve your family business and you have one kid who's in the family business and two kids who aren't, that one kid might end up getting more than the other two kids. Sometimes it's hard to equalize that, and that's okay. There's no law that says that your kids have to be all treated equally, but that can be kind of a tough wrinkle. Family members may end up as trustees for a widowed spouse. This happens a lot with family businesses. The family members don't want a spouse, an outsider spouse, to end up in the family business. So they put the business interests in trust, and then that spouse is a beneficiary of the trust so that they're not in the day-to-day operation of the business. And that could mean that the surviving siblings are having to be trustee for this widow or widower for the rest of their life. And that is kind of that can be a tough relationship, but it is a way to keep a family business inside the family. And then it limits to some extent the freedom of descendants to do other things. If your whole estate is tied up in this family business and you pass on the interest in the family business, then those two other kids could end up being brought back into the family business.
Okay.
Oh, life insurance policies. This is a product you may have heard of if you're a small business owner, and it is a good strategy, especially if your business is set up to be able to afford this. So this is a life insurance policy that partners or members of a company or partnership buy on each other, and it's a way for the other partners or the company itself to be able to buy out the deceased member's interest from the deceased member's estate. If you decide to go with this, just put a provision in the operating agreement or partnership agreement, shareholder agreement, or bylaws that says the company has the right to buy out the deceased member's estate. Otherwise, the estate doesn't have to sell. And so make sure that it's mandatory that they sell, the insurance proceeds pay out, and then you pay them for the deceased member's interest.
Kind of a slick thing,
Yeah.
tool to have to think about. So I'm gonna, I'll take the next couple of slides and then we'll get to our question slide. And so if anyone is thinking of other questions, now is the time to type those in that box and we'll hopefully get to them in the next couple of minutes. A couple of things on privacy and confidentiality. Estate planning documents and governing documents for your business are private and internal. You are not required to file, record, or provide full copies of these documents to any public entity or agency. So for some specific examples, you're not required in New Mexico to record your will or trust with the county clerk. Similarly, you're not required to file your operating agreement or other governing documents with the Secretary of State. So an LLC operating agreement, you don't have to provide that to the Secretary of State. So also kind of in that line of thinking, you can revise or revoke your will, or you can amend your operating agreement or other governing documents without filing or recording or telling anyone, if you put things into place and then you change it, you don't have to, keep any sort of public entity aware of those types of actions, completely private and internal. However, a bank or another agency might want a copy of your governing documents, like your operating agreement, to confirm who has authority to sign or obligate the business within the entity, or to confirm who is your designated agent on your financial power of attorney while you're living. Say you're incapacitated and you've named a business partner or someone that you feel like has capabilities to keep your business running as your agent. They may want a copy of that to confirm that that person can take actions on your behalf in conjunction with business finances. Similarly, a bank or another agency might want a copy of your personal representative's letters testamentary or their letters of administration, which are issued through a probate. So they want to confirm that this person is in fact the court-appointed PR, or your certificate of trust, like we talked about before, just to confirm who has authority to be acting when. Oh, Christina, do you want to take this one? The scams and pitfalls just to watch out for?
Sure. And we talked about, a lot of times lawyers will sell expensive trusts to clients because it's a big payout right now. So a trust might be the right option for you, but if someone is exclusively saying you need a trust, you have to have a trust, everyone needs a trust, then that might be something to watch out for. It's less popular than it was about 10 years ago as a product for lawyers to sell. Layered trusts are pretty popular right now, where it's a family trust that owns a business trust that owns another trust. That I think is an attempt to avoid paying taxes, and it doesn't work. So that's not a good option. And we talked about estate plans and business plans that aren't a good fit for your business and your family. And then the get-rich-quick schemes, we see a lot of those. Sometimes they do implicate trusts. And so if it's a self-published book or a seminar at a hotel. Just take all of that with a grain of salt. Some of it might be good advice, but just check it.
And then we have a couple of slides that I'm going to go through kind of quickly so we can get to your questions. So the Modest Means Helpline, our program, doesn't specialize in complex estate planning, and we don't draft estate planning documents. So we can give advice on those types of documents and on probate, but we do recommend that you seek advice from an estate planning attorney as to what type of estate plan would be most beneficial for you or recommended based on your specific situation and your small business. And in general, I don't know if we sort of emphasize this enough, but Christina and I both recommend that you do work with a private attorney to draft and prepare an estate plan, to have an attorney advising you on that who specializes in this area more so than the DIY route. It really is, there's a lot of things to keep in mind here. So estate planning attorneys, we recommend. Similarly, the Modest Means Helpline doesn't draft governing documents for small businesses. So we recommend a business law attorney. If you have a business that has investors of any kind, you need to be talking with an attorney who specializes in securities law, a business entity of any kind with investors, a securities law attorney. We don't specialize in tax law either. So we recommend you talk to a CPA. And a couple of resources. If you're looking for private attorneys on the State Bar's website, you can use the Find a Lawyer page. It's a search tool, and you can filter by practice area. So you could select business/corporations. You could select estate planning, taxation, probate, wills, and then you could select multiple practice counties or just the one that you live in. Our sister program, Modest Means Helpline sister program, the Legal Resources for the Elderly program, does have a financial power of attorney presentation and form on its webpage. You go to the same State Bar New Mexico website, and under For the Public and Legal Resources for the Elderly, under their publications tab, you can find more info on a financial power of attorney. And also the law firm that Christina works for, Law for Small Business, has a great blog. And the bottom link, so we recommend that you check that out for more information on all different types of small business topics. Specifically, Christina authored the article that's linked at the bottom about a lot of the terms that we've been discussing today on estate planning. So now,
another attorney here, my boss, on the blog, because I saw that comment, yikes, talk more about accidental partnerships. My boss has an article on the blog that's a really good overview of accidental partnerships. And so that's a good resource for that. But yes, yikes. And, just be clear and document. That's what I would say about that. Be clear about the parameters of a relationship and document, being clear about that. Yeah. Email's okay. Email is evidence.
Yep. Everything in writing, or as much as you can in writing. Okay. We'll try to get through these questions very generally. So the question is, because New Mexico is a community property state, how does that affect a business estate planning? If you are married, that's going to depend on the relationship sort of between the spouses, if they are operating the business together in some ways. But if someone who is a married person does not designate their ownership in an entity as their sole and separate property, then it could have some consequences in terms of a surviving spouse having a potential community interest in that business asset.
Yeah, our operating agreement this isn't a sales presentation, but the website has an operating agreement, L4SB. Our form operating agreement has attachments to it that ask the member's spouse to sign, that says that their community property interest will be satisfied out of the spouse's other assets and not the LLC membership interest. If you had your business before the marriage, that's separate property, but any increase in value of the business during the marriage is community property. So that can get highly litigated very quickly. So it is nice to have something in your governing documents that addresses that. And then also in your will or your estate plan that also addresses that. And it would be similar. It would say, my spouse's community property interest is to be satisfied from my other assets before it's satisfied from my business assets. And that's at sole and separate agreement. You can also have your spouse do a sole and separate agreement and make sure that that isn't coerced or, you know, found to be unenforceable for some reason. So make sure you treat your spouse with integrity and fairness.
Very good advice. Okay, last question. How is the validity of a trust or will verified if it's not filed with an agency? Talking with an estate planning attorney who's licensed in New Mexico and who specializes in estate planning, they should be able to opine or ensure that certain statutory requirements are met and that certain actions have been taken to like fund a trust or to have a properly executed will, for example. So working with an estate planning attorney, and also to the previous question that we had as well, you know, even if you're a super meticulous person that would think about, you know, or is motivated to tackle drafting your own estate plan, I recommend, our program recommends, Christina recommends working with a private estate planning attorney really to relieve yourself from that burden and to make sure that it's done right.
We do another sneaky thing at my firm. My boss is going to get mad at me for telling you all this, but we do a flat rate contract review. So if you did your own documents, it doesn't mean we fix your documents, but we will tell you like, oh, these documents aren't going to work. Or these documents look fine. Here are a couple of things that I see that are weak in it.
There you go.
And so you might be able to do your own documents and then have an attorney check them. Some attorneys will say, no, I'm not going to do that, but my firm will do that for you.
Very good point. And here's our contact information. You can reach me at our main intake. Christina's phone number and email address is posted there. If you have further questions, please don't hesitate to reach out to either of us. And thanks so much for being here. And thank you, Christina, so much for co-presenting. This has been great.
Thank you so much.
Yeah. So, okay. I hope everyone has a great rest of their afternoon and take care.